Your spouse didn't provide for you in his or her will. Do you have any rights of inheritance? Well, under Mississippi law, a surviving spouse has a right to inherit a child's share of an estate, regardless of whether they're provided for in the will or not. So we call this the election against the will, the right of a spouse to elect against the will. And the reason for that is we don't want, as a matter of public policy, for surviving spouses to be left destitute. And so Mississippi law has long provided that a surviving spouse is entitled to an equal share with the children of a decedent in the event that they're not provided for in the will. Now, that provision does have some exceptions. If the surviving spouse's personal estate is at least 20% of their child's share of the probate estate, then there'll be an offset dollar for dollar for the surviving spouse's personal estate against the portion that they're to receive. In addition to the right to inherit a child's share, the surviving spouse is also entitled to a right to reside in the marital home until either their own death or until they remarry, whichever occurs first. Because again, as a matter of public policy, we don't want surviving spouses to be left homeless. And so we provide for a legal mechanism that a deceased spouse must provide for their surviving spouse at least a place to live if in fact they enjoyed a marital home together prior to the decedent's death.